Hello and welcome to Lecture 1 for Topic 9. And in this topic, we're going to be learning about court structure and personnel. And in this lecture, we're going to be focusing on the structure of the court. So the courts or the judiciary is one of the three branches of government in American government. And as we know, those branches they do different things. They play different functions within a democracy. As we know that the legislature is the lawmaking branch. They're the branch that makes decisions. And when it comes to criminal justice, the legislature is the branch of government that defines crimes, it tells us what behavior is prohibited, and also sets the punishments, tells us that if you engage in this crime, this is the punishment you are likely to receive. The executive branch, it is responsible for enforcing that law, putting that law into action. And so in criminal justice, we see that the police, law enforcement, and so we say that a particular behavior is a criminal behavior, and the police are there to investigate and apprehend those who engage in criminal behavior. Prosecutor is a member of the court, but also is a part of the law enforcement branch because they're the top law enforcement official within their jurisdiction. And then in a few weeks, we're going to be learning about the Department of Corrections, and they are also a part of the executive branch because they take the punishment and they enforce it. They put it into action. So the courts, the judiciary, what do they do? What is their function within a democratic society? Well, the long and the short of it is that courts settle disputes, okay? And that's what their job is, that there can be a dispute over laws, whether they're constitutional or not. There can be disputes over whether or not laws have been enforced in a particular way. There are disputes over whether or not somebody's engaged in behavior. So let's take a look in more detail about what are the kinds of disputes that courts settle. So what kind of disputes do courts settle? Well, in criminal law, which you're studying this semester, the big dispute that's settled is, did this person commit a crime, right? And so that if that question comes to a criminal trial court, basically the dispute over whether or not that individual is actually responsible, has committed this crime, whether they're guilty, is that dispute is resolved. When it comes to civil law, disputes are resolved as well. And so the question that the court is settling is this person responsible for some sort of harm or damage that was caused by their actions? So is this landlord responsible for breaking a contract? Is this individual that physically harmed somebody from some sort of negligent action, failed to, remove the snow from their sidewalk, leading to somebody fall and hurt break their leg or whatever? Is the homeowner responsible for that? And so in a civil court, that's the question, and that's the question that is the dispute that is settled. Do we find that this individual is responsible? A question that comes to the court often is a question over the law itself. That when many laws, whether it's a city ordinance or whether it's a state law or whether it's a federal law, the question is, does this law correspond with our Constitution? Is this law constitutional? Are the actions of the executive, police, prosecutors, is what they're doing constitutional? And so in the last chapter, we learned about police and the rule of law. And so that when cops, frisk somebody based on reasonable suspicion, is that a constitutional act? And the court says, yes, it is. But in other instances, if cops say that they have a warrant and hold up a bunch of papers, and in fact, it's not a warrant, that's unconstitutional. And any contraband that's collected from that kind of search is inadmissible in court. The court settles that dispute over the constitutionality of law and actions. And the court exercises this, the Supreme Court of the United States. We'll be learning about the way the courts are organized in one moment. The Supreme Court of the United States has this power called judicial review. And what judicial review is that the Supreme Court of the United States has the power to nullify laws that are found to be unconstitutional. And so not only is the dispute settled in court over the constitutionality of laws, but if the Supreme Court finds that a law is in fact unconstitutional, that law becomes null and void. And an example of that, this isn't a criminal justice example, but as we know that many states had laws on the books defining marriages between a man and a woman only, in other words, prohibiting same-sex marriage. Question comes before the court in the landmark case of Bergefeld v. Hodges, but whether or not those kinds of laws that define marriages only between a man and a woman are those constitutional. And the Supreme Court said, no, they are not. And so all of those laws were nullified, opening the door for the legalization of same-sex marriage. Okay, so that's a good example of judicial review in action. Okay, so next we're going to be talking about the overview of the United States court system, how our courts are organized and the different kinds of courts. And these are some of the things that we're going to be talking about on the upcoming slides. The first thing we're going to be learning about is that courts play different roles within our society. Courts have different functions. The next is we're going to be talking about courts have different jurisdictions. What's jurisdiction? A jurisdiction is the authority to make legal decisions and judgments. So the court's authority to make legal decisions is different depending on the kind of court within the system. And then the other thing that we'll be learning about is how the American court system is a reflection of federalism and of federal supremacy. The federal law is supreme, and also that power is shared within the United States between the state and local governments. So let's dig in and take a look at these in more detail. Okay, so some courts are what is known as trial courts. And trial courts are the courts that hear the case for the very first time, okay? On the next slide, you'll be learning about the idea of original jurisdiction. And that means that some courts have the authority to hear a case for the first time. And so if a court hears a case for the first time, it basically means that it's a trial court. And so you have trial courts both in civil and in criminal law. And in the upcoming weeks, we're going to be learning about the legal rights that you have during a criminal trial. But what takes place in a trial court, and usually when I teach this class face-to-face, and this is a downside of, I love teaching online, but one of the downsides of teaching online is when I teach this class face-to-face, we do mock trial. And so when, you actually get to participate in a trial and you act as a prosecutor or a defense attorney or a member of the jury. And so what we're going to be learning about today in this week and in the following week about trial and pretrial activities, we usually get an opportunity to put that in action. And unfortunately, there's no way I could figure out how to do that in a virtual setting. So, well, here's to the end of the pandemic. So what happens in a trial court? Well, it's where the trial takes place. Evidence is presented. People come and provide testimony. There's a jury. The jury renders a verdict. And then the individual is sentenced. Those are all the things that take place in a court of original jurisdiction, a trial court. There are other courts that don't hear the case for the first time. And that's what's known as appellate courts. What an appellate court does is it serves as sort of a check on what took place in the trial court, okay? And so it hears an appeal on a trial court decision. So let's say that you are tried and convicted of murder, and then everybody gets a right to at least one appeal, and that basically you appeal to the appellate court. And you basically, each side, the prosecuting side and the defense side, the defense would submit briefs to the appellate court, making an argument for why that decision was of the trial court was wrong. So they might say, look, my client was found guilty, but that's because evidence was admitted into court that was illegally collected. Or my client was found guilty, but the jury instructions that the judge gave to the jury were unconstitutional, right? So we're appealing that verdict. The prosecutor then presents briefs for the appellate court to read to basically counter those claims that the decision of the trial court should be overturned. Uh, and so, what happens at a trial court is there's no trial, okay? But their role is to basically look at the trial court activity and see if there were any errors, and if there were errors in that trial court, then they correct those errors. There's no testimony, there's no like presentation of witnesses or evidence. That what happens at the appellate court are briefs are presented from each side. The appellate court justices read those briefs and then they render a decision. And the decisions that they can render are they can affirm the decision of the trial court. Basically said, we looked and saw whether or not that decision, there are errors in that trial court, and we found that there's not, so we affirm the decision of the lower court. That they could overrule the decision of the lower court. They could basically say that there were errors in the decision making of the lower court, so that we do not affirm the decision of the lower court. At that point, the case could just be thrown out, or they could say there were errors in the decision that the court made, and that it needs to be remanded back to the lower courts to the trial courts for a retrial if the prosecutor so chooses. And usually, unlike in a trial court where there's one judge, that in an appellate court, there's usually a bank of judges. So 3 judges, 5 judges for the Supreme Court, which is an appellate court, 9 judges, okay? And then you need a majority of the judges to render a decision in the case. Now, keep in mind that in a criminal trial, it's only the defendant who can appeal a decision. In a criminal trial, a prosecutor cannot ask for an appeal of an acquittal. That violates the Fifth Amendment's double jeopardy clause, that a person can't be basically tried twice for the same crime. And so if an acquittal is rendered, that is, the person is found not guilty, then it stops there. The prosecutor can't come back and say there were errors and ask the appellate court to review that. And then the final type of court is a Supreme Court. That, as we're going to see when we learn and look at the way that the court is organized, there are intermediate appellate courts and then there are Supreme Courts. And the Supreme Court is known as the court of last resort. It basically renders a decision that is the last decision that's going to be rendered on this case, if they choose to hear the case. That it for the most part, most Supreme Courts are appellate courts, so they don't hear the case for the first time. They hear it on review. And it is usually sort of the highest court in the system. And Supreme Courts usually serve an appellate function. But it's the same, that like with the Supreme Court, 2 sides enter briefs, the briefs are read, and then they come and do oral arguments in front of the 9 justices, and then the justices listen to those oral arguments, and then they go back to chambers, and they render decision, and then they write opinions. So trial, appellate, Supreme Courts, those are the different types and functions that courts play within the U.S. court system. Another aspect to the court system in the United States is that courts have different jurisdictions. And just to refresh your memory, jurisdiction is defined as the authority to make legal decisions and judgments. If a court has the legal authority or power to make decisions, it can do it. But sometimes courts don't have the legal authority to make a decision. And so they lack jurisdiction and they can't hear a case. So courts have different jurisdictions. One type of court that we were talking about on the last slide is the court of original jurisdiction. And so some courts they have the power to hear cases for the first time. Other courts are appellate courts. They don't have the jurisdiction to hear the case for the first time. Okay. So that's one type of jurisdiction that a court can have. Other kinds of jurisdiction that your textbook talks about are the difference between a court of limited jurisdiction and a court of general jurisdiction. We'll start with the court of limited jurisdiction first because it helps us understand the court of general jurisdiction. And so, a court of limited jurisdiction is the kind of court that has the authority only to hear certain types of cases. They can't hear all types of cases, okay? So, for example, the federal courts that you're going to be learning about in a second, they only have the jurisdiction to hear cases that deal with a federal matter, okay? If it's a question that only deals with a state matter, the court doesn't have the jurisdiction to hear those. They have limited jurisdiction. However, in your textbook, they talk about, like, when we're talking about state courts and the types of courts within a state court system, that there are some courts that just have the authority only to hear certain kinds of cases. And so municipal courts, they can only hear cases that have to do with municipal ordinances, city ordinances. They can't hear any other kinds of cases. Family courts, they have the jurisdiction only to hear family matters, divorce and custody cases, and those sorts of things. Your textbook also talks about specific kinds of limited jurisdiction courts that are known as specialized courts. And so your textbook talks about drug courts, talks about domestic violence courts, and other kinds of courts that are specialized in the kinds of cases that they can hear, and they're limited to the kinds of cases that they can hear. Thus, they are courts of general jurisdiction. The other type of jurisdiction is the court of general jurisdiction. And that a court of general jurisdiction may hear any civil or criminal case that's not already exclusively within the jurisdiction of another court, okay? And so the courts of general jurisdiction really have wide berth in terms of the kinds of cases that they can hear. Another difference between limited and jurisdiction, courts of limited jurisdiction, and courts of general jurisdiction. Generally, the courts of general jurisdiction hear more serious cases, felony cases. Courts of limited jurisdiction oftentimes hear less serious cases. Not always, but often. And so they are courts that hear, misdemeanor cases and those kinds of cases, okay? So that's a differentiation you should be aware of too. Okay, so the last feature of the court system that we're going to take a look at is that the court system in the United States is a reflection of federalism. So in the United States, federal law is supreme. That comes from the Supremacy Clause that's in Article 6, Section 2 of the Constitution. It basically says that the Constitution of the United States is the supreme law of the land. So any law in the United States that violates the Constitution is prohibited. It also says that whenever there's a conflict between state and federal law, and we sort of see that with marijuana laws. Some states legalize marijuana, but federal law, it's still a controlled substance. It's still an illegal substance. And so the Supremacy Clause also basically says that federal law trumps state law, okay? And so you're going to see with the way that the court is organized, that it is organized in a way that reflects federal supremacy. Also, the United States is a federal system. So national law, that first, it says the United States federal law is supreme. That's just another way of saying national law is supreme, right? But U.S. is also a federal system. We're predicated upon the concept of federalism. And federalism is the idea that the national government gets some power, the state governments get some power, and so that basically we have this power sharing relationship in the United States. And because of the 10th Amendment, and we know this from earlier in the semester, that a lot of the police power, that is the power to regulate the behavior and morality of the citizens that live within the United States, that's a power that's reserved to the states. That as we see in the court system, that the vast majority of court cases, particularly criminal cases, are handled by the state court system, not the federal court system, okay? Because that federal authority because that power to regulate the behavior of people is reserved and given to the states. And so as we're looking at the organization of the court system in the United States, you'll see that it reflects the principles of federalism, and it also reflects the principles of federal supremacy. Okay, so here is a diagram of the organization of the court system in the United States that comes from my American government textbook, just because I think it provides a more streamlined look at the organization of the U.S. court system. And you'll see, right there are some of the principles that we were talking about in terms of the way the court system is organized. On the left-hand side, you have courts that are dedicated to it's the federal system. And these are the courts that are dedicated to dealing with national law or federal law, okay? And so you have the U.S. district courts. Those are the federal trial courts. So if you are charged with violating federal law, like counterfeiting money or violating copyright laws or terrorism or whatever, right? That you would be tried in the U.S. district courts. And there are 94 U.S. district trial courts. Every state has one. The state of Wisconsin has two. We have one district court, federal district court in Milwaukee, one in Madison. Okay. But those are the courts of original jurisdiction for the federal level. That's where the trials take place. You also have intermediate trial courts in the United States. They're known as the U.S. Court of Appeals. They're also sometimes referred to as the U.S. Circuit Courts. They are an appellate court. They review the trial activities, what took place. They review the decisions that are rendered in at the U.S. District Court level. On the state side, every state has their own court system, and in a second we'll look at the way that the Wisconsin court system is organized. The state court systems, there's 50 different ones, and they are established through state laws, and so the state legislature establishes what the state court system will look like. But in general, they have a state trial court, that they have state appellate courts, and then they will have state supreme courts. So, and like I said before, the vast majority of criminal cases work their way through the state side on that graph, not the federal side, just because the federal government doesn't have as much jurisdiction over over crime. And then at the very top, and here's the federal supremacy, is the Supreme Court of the United States. Now, state Supreme Courts are the court of last resort when it comes to questions dealing just with the state constitution or state matters. But if you have a court case that deals with some federal matter, so if you have a state court case that, let's say, it as a product of the decision in that case, it gives somebody a sentence. Let's say that it sentences a 12-year-old to death, right? Well, the question might arise, is that cruel and unusual punishment? Does that violate the Eighth Amendment? And so since that triggers the federal Constitution, if there was an appeal on that case and that sentence in particular, that appeal could work its way way up to the Supreme Court of the United States, which is the United States court of last resort. The Supreme Court, you can watch this really great explainer video from Vox that talks in more detail about what the Supreme Court does. But that you have no right to hear your case appealed by the Supreme Court. You request a review from the Supreme Court. Very few are granted. But when they do accept the case and render a verdict, it basically is the last decision on that matter, unless another Supreme Court renders a new verdict, or whether we could amend our Constitution to sort of override the decision of the Supreme Court. But this is a nice little overview of how the court system is organized in the United States. Okay, so the last thing that we're going to take a look at in this lecture is the Wisconsin court system and how it's organized. This week within this week, I'll be making a video for your court report paper that's coming up. By the end of the semester, you are going to be visiting a courtroom, either in Waukesha County or Milwaukee, or really any county you want to visit the courtroom in. And so, keep that in mind in terms of when we're taking a look at the way that the Wisconsin system is organized. I'm just going to go ahead and put all of this up here, and then, we'll take a look at these individually rather than just going kind of click by click. In Wisconsin, we have municipal courts, we have circuit courts, we have courts of appeal, and then we have the Supreme Court of the state of Wisconsin. Okay, this is how our court system is organized. The municipal courts are courts of limited jurisdiction. They can only hear certain kinds of cases. They're municipal courts, so they hear city cases. They have exclusive jurisdiction over ordinance violations, and an ordinance is basically a city law or a city code. And so, that the municipal courts will, hear building code violations, disorderly conduct, trespass, parking, sometimes first offense, drunk driving, etc. And so these are the limited courts of limited jurisdiction. And all of the counties or all the cities in Wisconsin have municipal courts. They're not all full-time. I think only Madison and Milwaukee have actual full-time municipal courts, understandably, because they're big cities. Now, the circuit courts in Wisconsin, those are the state trial courts, okay? And the circuit courts are in the counties. And so you have Waukesha Circuit Court, you have Milwaukee Circuit Court, okay? And so those circuit courts are the trial courts for trying people who have violated state law, but they're tried in their county jurisdiction, okay? And this is the court that you're going to be visiting for your court report. You're not going to be going to a municipal court, but you're going to be going to the Waukesha Circuit Court or the Milwaukee Circuit Court, because they're the courts of general jurisdiction. They have original jurisdiction over all civil and criminal matters, and that's where the county district attorney, the prosecutor for the counties, that's where their offices do their work, right? Their offices aren't at the circuit court building, but that's where prosecutors work, right? That they are charged with enforcing state law, and they go, and if you violate state law in the county of Waukesha, you're going to be tried, or the case will be dealt with at the circuit court level. Wisconsin has courts of appeal, and so it's an intermediate appellate court. There are 4 appellate court districts. So the city or the state is kind of divided up into districts. There are 16 circuit court of appeal justices, 4 for each of the regions. They're elected, as is the prosecutor, and they serve a 6-year term. And like all intermediate appellate courts, they appeal the decision at the trial court, at the circuit court, and they render a decision. No, it relies on briefs. There's no trial or testimony or presentation of new evidence that takes place. And then the state of Wisconsin has a court of last resort for state matters, the Supreme Court of the state of Wisconsin. There are 7 justices. They are elected, and that they serve a 10-year term, and they have appellate jurisdiction. And so if somebody doesn't like the decision at the Court of Appeals level, the intermediate court, they can ask the Supreme Court of the state of Wisconsin to review their case for a final time. Okay, that's it for this lecture. In the next lecture, we're going to focus on court personnel, and we're going to focus on the prosecutors and the defense attorneys. I'll leave it to you to read about the judges, qualifications, way that they are selected for office. I'll leave it to you to read that in the textbook. Okay, talk to you soon.